I'm Kerry Raleigh Tipton with the Law Office of Kerry Raleigh, and today we're having an afternoon tea and learn, and the topic is overtime. And I titled it Overtime in the Fair Labor Standards Act, Why Do Employers Keep Getting Sued for Getting It Wrong? And I titled it that way just because it really is something that, it sounds so simple. If you ask people, oh, overtime, yeah, if someone works over 40 hours, I have to pay them time and a half, unless they're paid a salary or unless they're exempt. It seems pretty simple, but employers keep getting sued. I think last year, well, just from January through now, over 5,576 lawsuits were filed under the Fair Labor Standards Act in federal court throughout the country. Over 1,541 of those were in the state of Florida alone. You guys can work out the math. I think that's roughly around 27% of all overtime lawsuits in the country are filed in the state of Florida. So it's...
Oh, I see it. That's right.
Yeah, of the 5,576, 1,541 were filed in Florida. And that's just federal lawsuits. It doesn't, sometimes lawsuits can be brought in the state court. It doesn't include Department of Labor investigations, which would be in addition to that. But Florida's considered a hotbed of overtime litigation, and the numbers show it. I've been in practice now, I was just talking with the Jim, I've been in practice for 15 years. And of that time, I represent mostly employers and just countless overtime lawsuits. And they can range from, you know, a manual labor type position, a position of someone that you think would be exempt because maybe they were paid a salary, so the employer thought they were exempt. Then you have issues of that nature, both large and small. And in fact, I gave, just to get the scope of it, I have a press release from the Department of Labor, I think I do, that just listed all the, their news release of the different actions that the Department of Labor investigated over the years with regard to overtime lawsuits. And one of the news release was in May of 2013, they collected over $196 million from one particular company over overtime lawsuits because they misclassified a whole class of employees.
Wait, who did this?
The Department of Labor oversees the investigation. And
a specific company that got hammered?
Yeah. I'm sorry, it was $1 million in back wages. Over 196 employees were misclassified. And when we're talking about misclassified, it can be misclassifying someone as an exempt employee or a non-exempt employee, and I'll talk about those terms. Or a lot of times it's misclassifying someone as an independent contractor when really they are an employee. In this particular investigation, the employer had treated 196 workers as independent contractors when in fact they were employees. So then they had to go back 2 years to calculate the back wages. And then there's liquidated damages, and then there's other...
and then on top of that, there's a whole bunch of tax consequences with the IRS.
There are.
A whole bunch of
yeah. And that's why the Department of Labor and the IRS are now working together on a joint initiative to try to identify, find, and workers and employers who are misclassifying independent contractors, because it's taking a lot of revenue out of the IRS and other governments. So there's a joint initiative. It's on the Department of Labor's and the IRS's focus. It was part of, I gave a talk on independent contractors, interns, and volunteers, and how they're different from employees last month. There's a video on YouTube. And you guys could go through that for this different factors. But to start with, you'll see a fact pattern. I want you, on the materials in front of you, there's a fact pattern there. And I think the best way to kind of introduce the overtime in the Fair Labor Standards Act is to go through a scenario where you see the impact. And you'll see in here I highlighted some words. Those are some keywords that will be, some key phrases or issue spotting, as I call, that we'll be discussing throughout the presentation. But just to give you the impact, so here's the fact scenario, and I want you guys to put yourself in the role as the employer, the business owner, and then we'll talk about the lawyer's hat. What do you do when this happens? So I'll read it out loud. You own a firm that has 15 employees. You think of your employees as family. You give them holiday gifts in addition to bonuses. You know their kid's name when a family member is sick. You've been to kids' recitals, and not your own kids, but those of your employees, weddings, etc. Then one day you get a demand letter from an attorney representing one of your employees. I just named her Sally Riches because she thinks she's going to get rich. The letter claims that you personally and your business failed to pay Sally her overtime pay and that you owe her $190,000 in unpaid overtime and attorney's fees. After shaking your head in disbelief, you write down the facts as you believe them to be true, and you think you're okay, right? These are the facts that you write down. You paid Sally a salary of $72,800 a year, which is a weekly salary of $1,400. While you never said anything and you didn't put anything in writing, you assume that Sally knew that the $1,400 was supposed to pay for any and all hours worked within a work week, whether it was 20 hours, 30, 40, 50, or 100 hours. Because she's paid this salary, there is no way that she can win this case because she's paid a salary, she's not entitled to overtime. That's what this employer thinks. Because she was paid a salary, you didn't worry about keeping time records or having Sally keep track of her time. There probably has been some weeks where she worked more than 40 hours. Your best guesstimate is that maybe she worked 5 to 10 hours of overtime a couple of weeks out of the year. And because your business is a corporation, you don't think there's any way that you can be personally liable for this. Here's what Sally claims. It was expected that her salary was intended to pay her for 40 hours a week, nothing more. She worked 10 hours of overtime every week of the 3 years that she worked with you. You knew that she should have been paid overtime wages, but you willfully failed to pay it to her. So before you click the next page, I go through a calculation of just assuming Sally's claims are true, what the overtime implications would be. But just from looking at this and looking at you guys, what do you think the strength of Sally's position would be?
Really strong because nothing's documented. I mean, how are you gonna fight it?
Yeah. And there,
time records, no documentation of position, classification, what her job duties are, why she would be.
and we don't know, this fact scenario doesn't go through what her specific duties are. So because she's paid a salary, all we know she was paid a salary. We don't know what she did, what her responsibilities were, and that's important as we figure out later on whether or not she's exempt. So if you turn the page, how this implication.
I got a quick question.
Okay.
Let's say the employer says, all right, Sally, I'm giving you $1,400 a week, and you need to get your job done within that 40-week time period. I'm expecting you to do that because it's taking you 10 extra hours a week because you're not efficient enough. That's not a defensible position there?
No. You can discipline her for, if you have a policy, for instance, no unauthorized overtime, or if you see that she's talking a lot during the day and all of a sudden it comes at 5 o'clock and she starts to work just because she wants to get the extra hours. If she actually worked those hours, you have to pay her for it. You can discipline her later on for violating company policy. If she's really not a good employee, she's not keeping up with the pace, she's not doing a good job, you can terminate her for it. But any hours that she worked over 40, you have to, if she's not exempt, you have to pay her overtime. And that is one of the areas where employers get it wrong. And I've actually even seen employer handbooks where not only is that a violation of the law, but they actually have it in writing in their handbooks. And so then when you get this, imagine Sally's claim, and now she has, well, look at, they even have it in their handbook, this was willful. And I'm going to talk about why that willful sentence is important in a few minutes. So if we go through the calculations based on Sally's claims, at $72,000, I think $1,400 a week divided by 40, because that's what she's saying that it was covered. It's $35 an hour. So that her overtime rate is time and 1/2 that, which is $52.50 an hour. According to her, she worked 10 hours a week for 52 weeks out of the year for 3 years. That comes to 1,560 hours. The amount of unpaid overtime pay is $81,900. Under the Fair Labor Standards Act, you also get an equal amount in liquidated damages, so you times that by 2. So just looking at her unpaid overtime based on her claims, it's $163,800. But don't forget the lawyers, because the Fair Labor Standards Act actually specifies that if an employee is entitled to overtime, that they shall be awarded their attorney's fees. And I emphasize the word shall because that's what the statute says, and that means that the court doesn't have discretion. If she prevails, she must be awarded her reasonable attorney's fees. There can be discussion and argument as to what constitutes reasonable attorney's fees, and there's some strategies that when we go through this at the end to talk about how maybe you can minimize what those reasonable attorney's fees would be. But essentially, the employer has to pay for her attorney's fees, and then don't forget about your own attorney's fees. And for a case this size, I put a huge range on attorney's fees. When it depends on how quickly it's resolved, how far it has to go into litigation. In this type of thing, it could be anywhere from $5,000, rarely that it would be less than that, to well over $100,000, depending if it goes all the way through trial, and if other parties become involved. Now, you sit back and you see these numbers, and you also think, oh wait, there are 10 other employees who have the similar duties as Sally, who the same time and pay practices apply to her. That exempt, you thought Sally was exempt, but if she's not exempt, everyone in her same class of employees are not exempt. So now multiply that out by 10, and you're over $1 million, not even including attorney's fees. So that's how these types of claims, when an employer gets them, can add up to a lot very quickly. Obviously, these numbers and these salaries and like having the 10 employees, it's not for every employer, and it could be scaled down to, depending on what the salary or the hourly rate is for the employee that's asserting the claim. But adding the numbers up, it's costly for employers, let alone the time it takes to defend them and take away from their business. So,
well, and then just to point out where you said there's 10 other employees, the first thing the attorney's going to say is, I want all of them.
Well, not only is
from a sales perspective, the attorney's going to drill into this person
Absolutely.
and say, please, let's get these other people. It's the right thing to do. These people are getting abused. Now so there's going to be that pressure too. So, and then this person's going to talk with these other people and say, wow, look at what a good deal I'm getting. And the big bad man is
Absolutely. And you raised an excellent point. It's not only that the attorney's going to do this because they're seeking after it, but the Fair Labor Standards Act actually provides that the one employee can bring the overtime lawsuit on behalf of all similarly situated employees. After she makes some basic allegations, can get the court, ask permission for the court to allow a notice to be sent to all these employees saying, hey, here's this overtime lawsuit. Do you want to join in? Do you want to opt in and join this? Do you want to get paid money too? And that's something that goes through the court. So the other employees are going to find out about it.
Let's say that happens, and you mentioned it in the prior page about personal liability.
Yeah.
So you're telling me that they can pierce the corporate veil here?
It's not even piercing the corporate veil. Under the Fair Labor Standards Act, employer is defined as not only the business, but any individual who has management and control and directs the time and pay practices for that employee. So if you think of maybe if it's a smaller business, the president of the company is the one that oversees the time and pay practices for all employees. The president is going to be named as a defendant individually. And it's because that's how the law defines who and what constitutes an employer.
Is this Florida statute? Or
it's federal. Federal statute.
So you're telling me the human resource director of a small company can get attached to this lawsuit?
Yeah.
That's exactly what I was going to ask. Is that 80 employees? It's usually not the president of the company that establishing that policy.
It could be.
But it'd probably be both because he's still deriving the policy, driving the manual, driving the policies of the company.
There was a case that came out just out of the Second Circuit a few weeks ago where it did go up to the top person in the company, even though that person could delegate the powers to the HR director, that person ultimately had the power themselves to do it. And they ultimately had the one to set the direction of it. And the court, it went to trial court, and I was reading the facts of this case last night. It was kind of crazy. So it went to trial, and before it went to trial, the parties settled. And then the employer defaulted on the settlement. So that raised it back into the issue of the court. And then now you're going into issues of whether or not the person the top, I don't know if he was the president, CEO, I don't remember what his official title was, whether or not he was individually liable, went to the appellate court, and the appellate court rendered a 97-page opinion talking about how this individual was individually liable. And you basically look at their control over the operations, their power, and oversight over the pay practices, the time and pay practices over that employee. Who sets the time and pay practices?
So $40,000 a year HR director could get attached to a $1.2 million.
It probably is going to go up to the person above that person.
After the C-suite, there's more to go after.
It's going to go after the C-suite.
Okay, right.
Yeah. Not saying that
But
the
it could
HR...
be the CFO, I mean, so if we're talking a company that misclassifies a whole bunch of independent contractors that should have been employees,
Yeah.
the company defaults on it and it's a public company, then the CFO, all of a sudden the CEO, the COO, they
Yeah.
all as a group define company practice policy. It's, you know, footnoted in filings, and they're
It's
all
all
now
public
personally
record.
liable.
They can't, if there's a judgment against them, if it goes to
Highly
trial and a
likely.
find a judgment against them, it could be personally liable. That's why a lot of these cases do settle early on. There's two types of cases that you think of. One where it is a non-exempt employee is saying that the time wasn't accurately recorded, they weren't paid the overtime that they are owed. Not saying that they're not exempt, but just something in the timekeeping wasn't right. Maybe maybe travel time wasn't counted correctly or whatever. They weren't paid the right amount, but it's just them looking at their hours worked and the amount of money and the amount of overtime that was paid or not paid to them. Then you have the exemption cases where you're looking at...
I'm sorry to interrupt, but for folks that don't know what the distinction is between exempt and non-exempt,
Yeah.
can you just kind of throw that definition?
I will. So in looking at the Fair Labor Standards Act, it's whether or not it covers the employees. Not everyone is entitled to overtime pay. People who are exempt from the law are not entitled to overtime pay. People who are non-exempt are entitled to overtime pay. There are some common exemptions. The most common ones, what you consider the white-collar ones, executive, administrative, professional, outside sales, computer-related persons, and there's a highly compensated employee as well. There's different factors for each one. And if you fall within those factors, then you're exempt, and you can be paid a salary, and that's why you have lawyers, accountants, whatever, working many 100 hours a week and just get paid their salary. Then you have the non-exempt employees, and they're the ones that are entitled to the overtime pay. So let me go catch up the PowerPoint to where we are, because I wanted to give this as an overview just to spot the issues, and then now we'll go back a little bit and talk about the Fair Labor Standards Act itself.
And I would just to make one comment
Sure.
on everything you just said. In a lot of ways, it's another disadvantage for small businesses compared to big business. Because big business is going to have all the policies perfect. They're going to they love having these people that are salaried because they get away with murder. They get to work them 80 hours a week. They have it perfectly documented, and they have a huge advantage over the small business that first can't afford to hire those kind of high-paid people, and also aren't sophisticated enough to manage the process, outline the rules, etc. Whereas the small business people are in a whole different category because they, not only do they have to consider all these things, but they don't get the advantage of having 12 workers that are working 80 hours. When you look at their effective rate, it's the same rate they're paying their people.
Yeah.
And yet they're getting the best of the best, the creme of the creme out of Harvard, out of the best school. So it's another sway, and it's a tricky thing that big business has done to, take a huge advantage.
They do. They're more sophisticated in these ways because they have more sophisticated people working for them. They have the resources to do it, and so they know they probably have in-house counsel or they have outside counsel that help draft these things. Small business owner is, a lot of them are, husband and wife business. They're doing everything themselves. And in my fact scenario, I referenced that the business owner thought of their employees as families because I represented small business owners. And there was just a case I had last year, and the owners got sued for overtime and some other claims. And it took them a lot to get over the shock and just, I almost want to say sadness over being sued, because this is something there was a time where the one employee didn't have money to get Christmas gifts for his kids, so nothing related with work. They got Christmas gifts for his kids. One of his children was sick in the hospital. They went to go visit the child in the hospital. Now, there were some issues because they didn't know exactly what needed to be done. They thought what they were doing was fair, but it really didn't comply with the law. And so they had to make sure that he was paid the overtime pay that he had worked. And so later on, I'll talk about some common mistakes and some errors that employers do, thinking that they're being fair and that's okay, but sometimes being fair just isn't enough to be compliant with the law. So some basic concepts with the Fair Labor Standards Act, you'll see a few things. One is coverage. Who does it apply to? And then the actual provisions of the law. It deals with minimum wages, overtime pay, youth labor, and record keeping. I'm going to talk primarily about overtime pay today. But first, let's go to coverage. So first you have to look at, is the employer covered under the Fair Labor Standards Act? In short, almost all employers are. You can be covered under one or two ways. Enterprise coverage. Your business is covered under the law if you have, I believe it's at least 2 employees and you gross $500,000 in sales. If that's the case, you have enterprise coverage, and then you're satisfied that all your employees are covered under the Fair Labor Standards Act. Doesn't mean that they're exempt or non-exempt. It just means that you have to they're covered under the law, and now you have to decide whether or not your employees are exempt or non-exempt under the Fair Labor Standards Act. If you don't have enterprise coverage, the employee may still be covered under individual coverage, and there are different ways that they can be individually covered, and that's kind of small. One of the tests is, are they engaged in interstate commerce? Are they in the production of goods for commerce, and are they closely related process or occupation directly related to such production and commerce? Now, interstate commerce is defined broadly and it's easy to satisfy that. If you have a receptionist making phone calls across state lines, she's most likely engaged in interstate commerce. If you have, like, say, a receptionist that's making a phone call to another state, to Georgia, any other state other than, we're here in Florida, so other than Florida, then she's probably engaged in interstate commerce. If you have an employee that's processing credit card payments and your credit card processor is in a state other than Florida, or the person who's making it, the payments from a state other than Florida, then that employee is engaged in interstate commerce. In short, the short answer is almost all employees are covered under the Fair Labor Standards Act. There will be instances where that's not the case, but more likely than not, the Fair Labor Standards Act covers your business and your employees. So then you start looking into, what are the provisions? What is it that I need to know? What is it I need to comply with? Minimum wage is simple. Federal minimum wage is now $7.25 an hour. Florida is $7.79 an hour. So the federal is a minimum, is a bar. So in the state of Florida, everyone has to follow the state rate, which is $7.79 an hour. Then the overtime means all covered non-exempt employees are entitled to time and 1/2 time, their rate of pay for all hours worked in excess of 40 hours in a work week. And then with record keeping, covered employees must keep certain records with regard to their employees. Accurate time and pay records is one of them. The Fair Labor Standards Act puts the burden on the employer to maintain these records and to prove the reliability and accuracy of these records. So traditionally in a lawsuit, you think of the plaintiff. So in our fact scenario, the plaintiff would be the employee. Typically, the plaintiff has the burden of proof in lawsuits, right? That's still the case in the Fair Labor Standards Act. However, the employer has the burden to show the reliability and accuracy of their time and pay records. In the non-exempt cases, these cases hinge on the time and pay records. So although the plaintiff has the ultimate burden of proof, there's a lot that the employer has to prove. And if they can't show that their time records are reliable or accurate, they're going to be in trouble. They're going to be exposed to liability.
And what do you recommend on that? Just a regular timekeeping software is fine, right?
Yeah, there are different ways. It depends on the type of business.
It should be input by the employee, because if they input it, then there's no argument to say, oh, I didn't input that time.
Yes and no. However, there is the argument that you get You know what, I worked off the clock every morning for 15, 20 minutes every day. My manager told me to work off the clock. They knew it. So although the time records showed this, I worked off the clock. That's the claim that you get sometimes.
Oh, because and then that goes back to the manual saying, oh, no over 40 hours.
Yeah.
So I was threatened by losing my job, so I didn't book it. And then
Yeah.
20 minutes after work.
And so now in terms of litigation, when you have a claim of that, and then it presents a fact issue. So in order to prove a fact issue, you need to start, one, what documents can you show? Well, the time and pay records don't show this, so now you have to start interviewing other employees or the managers. And if things start showing one way or the other, that's going to help you assess what your potential liability may be at jury trial. However, if it is a genuine question of fact, which in these types of cases these are, that is something that as a litigator you think of, and here's why. And I talked about this in one of my other claims. When you look at the life of a lawsuit, the person files the complaint, and then there's an opportunity for the defendant to see if it can get dismissed. That's early on. And it gets dismissed if they don't state a cause of action or something under the law. That's easy for for a plaintiff to overcome that hurdle a lot of the times. So then the next stage is summary judgment. Between the dismissal stage, if you can, just basing at that motion to dismiss stage, the court has to assume that all the allegations in the complaint are true and make inferences in favor of the plaintiff. So plaintiff overcomes that stage. You get to the summary judgment stage. You do discovery. And when you do discovery, that means taking depositions, getting evidence, records, documents from other people, interviewing things, getting affidavits, and then now you have the evidence. You get to something that said, look at the court. Court, we have all this evidence. We even deposed the plaintiff. Everyone agrees as to these set of facts. Applying these facts to this law, we win. And if you do win, that's it. You're over, you're done. You don't go to a jury trial, you're done. So from summary judgment now to a jury trial, a lot of time takes place, a lot of attorney's fees happen, a lot more work has to be done, and the uncertainty of a trial. You just don't know what the trier of fact will do. So when you look at the case, you look at, is this a type of case that there's going to be a genuine issue of fact, of material fact? In the overtime cases, in that type of scenario where someone says, I worked off the clock, that's something that probably creates a genuine issue of fact that gets you past summary judgment. So now you're looking at the exposure in terms of time and fees as something that could take you all the way to trial. And that's what makes these cases so difficult and easy. It's easy for the plaintiff side, difficult to defend, because summary judgment in a lot of cases is a vehicle that defendants like to use when they can, but it may not be available in these types of cases. Because a lot of times they just say, the employee says, I worked off the clock. They said that I didn't. You have a he said, she said. That's a question of fact. So
There's really nothing I do.
yeah, you can try, maybe you can get inconsistent statements from that actual employee. You can talk to other employees and see what they say. And they said they worked off the clock. That means that they were if according to their situation, that means that they would have been at the workplace at this such and such time, but you have evidence that they were somewhere else at that time. It takes a lot of investigative work, to tell you the truth, to disprove it, but sometimes you can. So, and I think I'm saying it, so it sounds simple, but both.
If you have cameras in your
I know.
place.
They do. Some do, and there are some things that, so when you talk about things that what employers can do for their timekeeping, depending on where the people work, the type of timekeeping system may be. Sometimes if people are in the car, you can have systems where you call in through your phone, systems that are on the computer. There's no set requirement on the type of timekeeping system you have to have. It just has to show the hour. You can even have that. Yeah. It has to show the hours worked, time off for breaks, things of that nature. I would take the actual measure too. Whatever the pay period is, whether it's weekly or bi-weekly, give a little summary to your employees saying these are the hours that you worked. If you think that it's different or you worked more, let us know. Otherwise, just initial that you reviewed it and you're confirming that it's true, this is an accurate reflection of the number of hours that you worked. It could be like a simple, shorter than what I just said. It could be a very simple statement, have them initial. Because now when you go to trial, if it gets to that, when it's a he said, she said, and they're claiming this, you can be like, well, later on, the employer presented with you with this, and you previously said that it was correct, and now you're not. Should we believe you now, or should we believe you then? Which is which?
Now it's back to the he said, she said of yourself.
Yeah, exactly.
Better. Well,
And it's something that in the fact scenario, I highlighted the word willful. So under the Fair Labor Standards Act, traditionally, the employee can go back 2 years to unpaid wages. So you look to see where they are, and then you can go back 2 years in time to see what type of unpaid wages or overtime that they're owed. If it was a willful violation, you can go back 3 years. So in this type of situation where the employer is making every effort to make sure that their time and pay records are accurate and reliable, that simple thing that I just said, that's something to show that it was not a willful violation, that they were trying to act in good faith, and at least it can limit it from 3 years to 2 years. It's hard to get the 3 years.
Quite a bit of money.
Yeah, it makes a difference. So
Would a boat delivery captain be exempt?
I would have to look at the specific duties of the delivery captain. Are they the two that come in mind would maybe be the executive exemption, and the things that I'm looking at, are they being paid a salary of at least $455 a week? Yes. And is that salary free of deductions, regardless of the number of hours, the quality or quantity of work? They're still being paid at least $455 a week. Then that's the first two requirements, check. If for some reason, say the weeks that they worked 30 hours or they took a day or two off, that you deduct from their salary, if you don't have certain things in place, you just were not able to check that off requirement, and that makes them non-exempt. Then you look into their specific duties. If it's for the executive one, they have to have some executive managerial responsibilities, supervise or manage at least 2 employees, have hiring and firing authority, and basically affect the their duties, or their primary duties are with the direction and management of the business. So if you look at a boat captain, if they're supervising other deckhands, would that be the right word? So
mates.
If they're supervising other mates, or at least 2 of them, then that's a check that we can look at. Do they have hiring and firing authority? Could they fire a deckhand or a boatmate without going higher up? Or even if they have to go higher up, if their recommendation is given serious weight, that may consider that. Are they setting the course of the boat? Are they determining the best way to, I'm not exactly sure what a boat captain does, but I would look.
Carrying the sea.
Yeah. Yeah, are they doing all those things? So you would look at their specific duties. So that's a strong possible maybe. Without knowing more, I wouldn't want to give a definite answer. When someone comes to me and says, Kerry, is this position exempt? I go through a checklist of things. I go through like the basic checklist of what I just did here. Then I'll do case law review, and then I'll review the Department of Labor opinions, and then form an assessment based on that, whether or not the person's exempt or not exempt. Some positions are easy. If you're asking me if a lawyer is exempt, yes.
And all lawyers. For any law firm.
If they're working as a lawyer, just because you have the ESQ behind your name and say you're working, I'm trying to say I'm a lawyer, I'm licensed in Florida, but I want to go live and work in North Carolina. I'm not licensed in North Carolina, so a firm hires me as a paralegal. I would not be exempt there, because even though I'm a lawyer, technically, I'm not authorized to practice law in North Carolina. Someone else would have to supervise my work, so I would not be exempt. So if they're not practicing or performing the exempt duties, then they won't be exempt.
What about a lawyer in training that hasn't passed the bar?
That doesn't pass the bar, a law clerk, most likely not exempt.
So somebody just helping.
Yeah, because if someone else has to supervise their work and sign off on it, they haven't finished the advanced level of prolonged course of study, which is one of the factors for that exemption, then they're not going to be exempt.
So CPA firm, same thing.
Yeah.
So if I have a staff accountant that's working 55 hours a week and under a salary, doesn't pass the CPA exam.
Does something have to be, it would depend on specific, because there are varying levels of accountants that haven't passed the CPA exam, right? So I think in some,
It's typical in our industry to work 55 hours a week during business.
yeah. I'm thinking an accountant is different. A junior accountant is different than, I was thinking of a law clerk, not a junior associate. So think of like a college intern in accounting.
Yeah, well, I'm talking, more of like somebody that's.
Like a junior associate, a junior accountant, probably, again, you have to look specifically at what they're doing, but they're going to be more on the scale of probably being exempt. Now,
But if they're
a
not
bookkeeper,
CPA track at all and they're just doing write-up work, that's the bookkeeper side.
do they have independent discretion and judgment?
I mean, they run their clients.
Let's go through the different exemptions and then we'll talk about that one when we get to it.
Okay.
So really quick, I just said, as we're going through this, how the overtime requirement seems simple, but yet employers, and the title of this talk is, why do employers still get it wrong? They still get sued, both large and small employers. I put a couple of, headlines in there from the May 2013 Department of Labor investigation that found 196 employees misclassified over $1 million in back wages. In 2011, a Florida-based company with different locations throughout the state was found to owe over $754,000 in unpaid wages.
Wow, 18 million.
Yeah, UPS, a broad company.
That could start with one employee, like you're saying.
Yeah.
One guy goes in and says, they find a discrepancy, and then boom, it's spreading across the whole.
Because here's the thing in those larger companies, say you have a whole class of employees, assistant managers.
Right.
You label that assistant manager as exempt, but that exemption is lost or they're not exempt, and even though it affects, you don't just lose it for that one employee, you lose it for the whole class of employees.
Wow.
So it can be detrimental for large companies like that, and I don't know, it's been a while since I read on that case. I forget it has to be it was a classification case where they probably misclassified things. A lot of times you'll see that with assistant managers. The employer wants to elevate them to an exempt status, but at the end of the day, everything that they do has to be reviewed. If they follow set protocol, you will order these supplies when X, Y, and Z happens,
Right.
then that's really not an exercise of discretion and judgment. I represented, it just seems like yesterday, I think it was like 2007, 2008, my firm, I was part of a team that represented a large national retail company, and it was a misclassification over assistant managers. And the implications of it could have been huge. It ended up being resolved.
You were defending that.
I was defending it, yeah.
Oh, so they were good.
Well, it was resolved through a settlement that required sums of money to be paid, but it didn't go through the court. It didn't go all the way through trial.
So they still have to pay
They
all the
settled.
legal fees too for both the plaintiff and
Yeah.
you guys.
Yeah. And
That first one there over in Pinellas County, there's a big operation where all those guys, a lot of those guys doing the cable for Knology and Bright House, they're all considered independent contractors.
Bright House, there was a lawsuit in an opinion from the 11th Circuit, so that's the appellate court that Florida's a part of. It came out in July that a contractor of Bright House, of the large cable company, was found to have misclassified all their cable installers as independent contractors, and it was found that they were in fact employees. They remanded it back to the state court to make more findings of it, but that issue has just been addressed this past summer with cable company.
Yeah.
So that's going to have effects across all cable companies. Probably
Yeah.
there's going to be more lawsuits because they all do that.
Yeah, because once, and then it gets in the
Verizon
news,
does the
you hear
same
about
thing.
it. Yeah. Now,
Yeah.
it's going to depend on the specific practices of that company. Just because it wasn't right in one company doesn't mean it necessarily won't be
Right.
right in the other. You have to look factually as
Right.
to how they're treating the people and what they're doing.
Because they could have better policies and procedures.
They could have better policies and procedures. They could be it's not just having the policies in place for independent contractors, how you're actually treating them.
Right.
If it is something that the main test over independent contractors, who has control over the manner and means in which the job's being done. If the business has control over that, then the person, even if you call them an independent contractor, even if you give them a 1099 form, even if you have a nice, beautiful independent contractor agreement, they're still an employee. if the independent contractor controls the manner and the means of how it gets done, they're exposed to the profit or the loss or the risk of how they do it, then they're more likely a bona fide independent contractor. So.
How does that relate to freelancers?
Well, a lot of people, freelancers, I think a lot of people treat freelancers as independent contractors, so you're still getting the same analysis that you'd have to do for independent contractors would have to be done there. Now, if a freelancer, most likely a freelancer, it's pretty typical that they're going to work for more than, I'm thinking like freelance writers. They're going to submit work to more than one person. They're controlling the topics of what they're writing, and they're submitting on how they're doing it.
But I think in a lot of cases they're not. And they're not necessarily controlling the content of what they produce. Essentially, they're there as a resource to produce a certain script, to produce a certain document, but they're giving direction. And they kind of fit into a team.
Are they given
being directed elsewhere?
Are they given direction over the top? Like, here's the topic, here's what the end product I want to look like, but you go ahead and make it happen yourself and you do it. So that scenario, that's okay, because they're still having, I'm giving you the topic, the end result, but I'm telling you to control how you're going to get it done. You decide how it's going to get done. You're using your own equipment, your own supplies. You're determining what hours you work on it, who you may else bring in on it. That's going to put you more on the side of the freelancer and the independent contractor in that scenario.
Lots of firms are using what's called a distributed workforce nowadays. And people may be all over the country and they're just coordinating, bringing in certain resources to bear on a project that has that need.
You're seeing more and more employers using independent contractors, and I think, which is why the Department of Labor and the IRS has their joint initiative, because they're seeing this happening in the private or in the workforce sector, and sometimes it's correct, sometimes it's not. I think people are doing it to try to save money, maybe more on the small business owners again, and they just save money on
the employment taxes, 7.65% of the
Yeah.
thing, all the workman's comp, all the if they get fired, unemployment,
Yeah,
all that stuff.
I know. That's why the
Depending
IRS
on
is
the
interested.
source of your primary source of income too. Like a lot of these freelancers probably have 10 clients.
Yeah.
So that's obviously not an employee, because you can't say you have to be here on Monday through Friday between 3 and 6 o'clock, and this is what you're doing. This is your place of employment.
Yeah.
These guys, like me as an accountant, I show up, I do what they want. I'm still kind of, even if they manage the process, I still have multiple clients. They're like, hey, do this based on this. It's a specific job.
You're controlling the manner and means of how it gets done, and
It's
you
a
have
specific deliverable. It's not just like, hey, you're just working on as my employee for a while.
Yeah. Here, I want you to write this for me. Here's an outline of what I want it to say. Here's my computer. I want it to, be this parameters. I want you to do it from 10 and 2 o'clock today. I want you to use this font, this style, this, that may push someone more into a part-time employee, but it's very fact specific in those classifications. So,
like you said there, provide the equipment.
Yeah.
Like I'm using my own computer, but if you provide me my own computer, well, now you're like, well, wait a minute. Why would you have your own computer?
Yeah. In and of itself, who supplies the equipment is one of several factors. So if everything else points to the independent contractor, and that's the only thing that may not lose the independent contractor status, it may. You have to look at it in the totality of the circumstances.
Right. Becomes more akin to
I guess. I think the Department of Labor refers to it as the economic realities test. There's a series of factors. The Department of Labor have their own series of factors. The IRS has their series of factors. The court system through case law has their own series of factors. You have to comply with all of them. But the big overriding umbrella that covers all manner and means over the control of the work and the economic realities between the parties. So common mistakes, which we're kind of catching up here, misclassifying employees as independent contractors or interns, misclassifying employees as exempt when they're really non-exempt, not keeping reliable time and pay records, and not calculating the correct overtime rate of pay or the hourly rate. I know that sounds simple, so I'm going to go in reverse order. Some issues with not calculating the correct hourly rate or overtime rate. It's some issues that may come up. Do you consider bonuses as part of the rate of pay? It depends. Depends if it's considered a production bonus or a discretionary bonus. A production bonus is a bonus that says if you do X, Y, and Z, I will give you $1,000 as a bonus. That's a production bonus, and that should be included into the calculation of the hourly rate of pay and then the overtime rate of pay. If you have a discretionary bonus that at the end of the year, I'm just going to wait and see how the business is doing. I may or may not give bonuses. That's on the discretionary side, and those bonuses are not considered to be part of your hourly wages or overtime pay. Commissions are problems sometimes on how you treat them in calculating the overtime pay. If someone is being paid a salary, but they're not otherwise exempt, so it's an overtime issue, you look at what's the correct way to determine their effective hourly rate. Going back to my analysis here, I specifically said two different things. One where the employer said that the salary was intended to cover all hours worked, and one where the employee said, no, my salary was intended to cover 40 hours. There's a difference. The employee's version is a fixed salary, the employer's called a fluctuating salary. For the fluctuating salary, it's a situation, I'm the employer, I'm paying you $1,400 a week. It's intended to cover all hours worked, whether it's 20, 30, 40, or 100. Then, when that person works overtime, and it's going to vary each week depending on the number of hours, you take the salary divided by the total number of hours worked, that gives you the hourly rate of pay, and then you only have to pay half that rate for the overtime hours because they already got the salary for the regular rate of pay for the overtime. If it's for that fixed rate, then you take the salary divided by the number of hours that it was intended for. That gets you the hourly rate. Then the employee gets time and 1/2 time for hours above that. Did that make sense?
Yeah,
So it makes a huge difference.
The first one I'm a little confused on, so you only get the 0.5 additional, that's because
Yeah.
we've already paid them
Yeah,
theoretically. But why is that?
because your salary is covered. So your salary is your regular rate of pay. Think of it that way, right?
Got that.
And that regular rate of pay was to cover 50 hours. So from 40 to 50 hours, you already received your regular rate of pay because that salary was intended to cover that. So therefore, you are only owed the half-time rate for those hours.
And this is just for salaried employees.
This is just for salaried
So
employees.
if you're not a salaried employee,
Non-exempt salaried employees.
and if you are a regular salary, if you're not a salaried employee, then you have to pay the 1.5. But in this first case study, this scenario, I have to break it down further. The scenario where I just said where you only have to pay them the half-time rate for the hours, it's for salaried, non-exempt employees who are working a fluctuating work week, meaning that the salary was intended to cover all hours worked. That needs to be clearly explained to the employee. My advice to employers is put it in writing. It could be in a simple, your offer letter. It could be you're paying you a salary of X. It's intended to cover all hours worked within a work week. Your hours may fluctuate from work to week, but here's your salary. That's good. That's good. Very important.
If it's a fixed salary, then they have to pay, say it's a fixed salary for 40 hours for a non-exempt employee, then you still have to pay them time and 1/2 time the regular rate of pay.
Oh,
Yeah. And when you do the math and you get these types of claims, you look at it, it can make a big difference.
Interesting.
So those are some issues in calculating the overtime rate of pay or the hourly rate of pay. Not keeping reliable time and pay records, we talked about that briefly, so I'll just hint on that again, that it's important to do that for your non-exempt workers. Even if they're salaried, non-exempt workers, you got to keep track of their hours worked. And I know sometimes employers they don't have a difficult time with this, but sometimes employees place a level of prestige or status by getting a salary. So when you take them, what do you mean I have to keep track of my time? I'm a salaried employee. So you have to work on how you present it to the employee. But if they're non-exempt, when it comes down to it, you're going to be the responsible one as the employer to show the number of hours that they worked and what you paid them for it. Misclassifying employees as exempt. So now, here's where we're going into, we talked about this briefly already, the exemption status. So when I talk to a lot of people, they think just because I paid someone a salary, like the employer in my fact scenario thinks that that's all that you need. That's just one criteria. So like I said, the most common exemptions are what's considered the white collar exemptions, which is executive, administrative, professional, 3 separate exemptions. The outside sales exemption and the computer related employee exemptions. Then there's a highly compensated employee exemption. There's a 7I, it's considered a 7I retail sales employee exemption. I'm not going to go through all those. I'm going to go through like the main white collar ones. And for those, for each of those, the person needs to be paid a salary of at least $455 a week. It has to be a true salary, meaning you cannot make improper deductions from it. The Fair Labor Standards Act specifies a specific number of legitimate deductions from it, but generally, if the person, it cannot be deducted based on the quality or quantity of work. So if the person takes a day off, you can't make a deduction from their pay. If they fail to show up with no explanation, you can't dock their pay. If there are some procedures that an employer should take that would help them in this situation, because now, go back to what I said, if you lose the exemption status for one employee, you lose the exemption status for all the employees in that same class So you have one assistant manager that otherwise everything else is fine, but you made an improper pay deduction. Now you just lost that exemption status for that employee plus all the employees in that class. The Fair Labor Standards Act realized, look, or the Department of Labor, and that's a little difficult. Let's give employers a way out. So you can have a safe harbor policy that has to have certain requirements in it that basically gives the employer an opportunity for the employee to say you made an improper deduction, you fixed it, so that it doesn't lose the exemption status. There's other requirements to that. The safe harbor provision needs to be in writing. It should be in your employee handbook. But that's something, when you ask about what employers can or should do, that's one of the things that they need to make sure that they have. So now for the executive exemption, the key things are having the primary duties being involved in the executive or management of the business, authority to hire and fire people, and supervise at least 2 employees. The administrative exemption, once again, the salary level, the salary basis, plus the primary duties has to involve work involved in the the management or operations of the business, meaning a bookkeeper may be an administrative employer because they're keeping the accounts and the records that help the business run as a business, as opposed to someone that's assisting in making you like sell your products or sell your services. They're working more on production stuff. That's not going to be an administrative employee. Plus, this person has to exercise independent discretion and judgment. Some examples may be some HR employees would fall under the administrative exemption. The junior accountants, maybe if they're servicing clients, though they're probably not going to follow under the administrative exemption because they're actually doing something that's the product, the service of the business as opposed to the administration of the business. Then you look at the professional exemption, salary level, salary basis. Now it's something that requires advanced learning, a prolonged course of study. Lawyers, accountants, doctors, it doesn't just have to be that. It doesn't even have to be a degree. It could be a prolonged course of study. And then the other exemptions. In your materials, I gave you a PowerPoint of the Department of Labor. So I was looking through things last night and I saw this in my stuff, and it's just it's like 97 slides. It goes through some of the exemptions. I'm not going through all of it today. I can, don't need to do that, but it's such a good overview and summary of the Fair Labor Standards Act. It goes into the issues that I discussed today that I wanted to give it to you just to glance at, refer to it from time to time. It is going back from one of my earlier talks where I was talking about copyright issues. Something like this you're allowed to print up because it's a work of the federal government. It's not subject to copyright protections. We're all allowed to use it. It made my night really easy last night when I saw, great, I really like this, easy. And it is something that just gives a good overview of the different issues. And that's one of the main things, or the point of my videos or my talks, is to help people. You're not going to become experts in this in an hour. But hopefully maybe you can get to the point where you can spot issues. Or maybe you have a client come in and they talk to you about something that they're doing. You can help spot an issue for them so that they can go to the people that they need to correct it.
Yeah, like you.
Like me.
Yeah.
Thank you.
Yeah, or like I'm doing an audit of a client and I see some kind of weird personnel thing like this, or a 401k audit, or.
Yeah, and it
Yeah.
comes up.
This is good, this makes us look smart too.
And it's something, like I said, the Department of Labor, there's not copyright issues on it. You can, I think the URL on it, feel
So
free
if-
to pass it on to clients.
If a company wanted to engage you to do an evaluation of their situation, what do you think I mean, let's say like a 50 employee company with executive management team, a management team, and then an employee side and probably sales, of course. And then you were gonna do, a write-up to make
Like
sure.
an audit of whether or not they're exempt or non-exempt.
Right, to make sure that they're okay, kind of a protective situation. They're growing, maybe they're looking at more acquisitions, and you want to make sure everything's good for now, and keep layering stuff on. What would be a typical engagement for you, and how long would it take?
It depends on the number of positions, not so much the number of,
Yeah.
the number of positions, and then it would involve a little bit to the number of employees, because just you have the position, the job description, you have to make sure that the employee is actually doing the jobs that are described as their duties and responsibilities. So it will depend on the number of positions, the number of employees, and it could vary. Sorry. And it is something. And it is something, once I talk, like in a situation like that, I would probably meet with the employer, ask these questions, and then it's something that I could probably do at my hourly rate, or depending on the situations, I may be able to offer a flat rate for that, just so that they know that there's they can put it in their budget, this is what it will be.
And then they can document it, throw it in their personnel files, and plus you at the same time can probably review their manual,
Make sure that safe harbor policy is in there.
So for a growth company, that could be a very added value service.
Yes, it could be. Thank you, Dolly, for that very good question. So now it's a quiz time. So it's true or false. Let's see if you guys can all answer out loud. I don't have to worry about overtime because all my employees are paid salaries.
False.
Very good. Falsa schmalsa. All my workers are independent contractors because I make them sign an independent contractor agreement.
False.
Look, they could be independent contractors, but you have to look at everything else. That's not, okay. Look, I'm a small business owner and my employees understand that. When I get busy, they volunteer to work extra hours. Because they volunteer this time, I don't have to pay them wages for their volunteer time.
Super false.
Yeah. There is no such thing as volunteer work in private employers, private entities. For charitable religious organizations, there may be volunteer work there, but for private companies, there's no such thing.
If you get sued for this and don't pay, you go to jail, right?
Well, there can be criminal penalties to it. I personally have not seen, the statute does say that. I've never seen anyone go to jail for it.
The IRS side, you very well could, like you don't pay those taxes. For all your independent, like that misclassification. Independent contractor, you don't pay it, you get attached.
The statute provides for criminal penalties in addition to civil penalties. The civil penalties are what I said before, the unpaid overtime, liquidated damages, go back to possibly 3 years plus the attorney's fees. But the criminal penalties, as well as the civil one, again, extend to the individual liability for the person or persons who have control over the pay and practices.
So you get to go to country club jail.
Yeah. So let's see. Our employee handbook specifically states that no employee may work unauthorized overtime. Therefore, when an employee works unauthorized overtime, I do not have to pay them overtime, pay for these hours. They violated company policy. See, you were very good question. When my employees make certain identified goals, I pay them a bonus. Because this is a bonus, it does not affect my employees' regular wages or overtime wages.
False.
Good.
It would be a production bonus.
Very good.
So you could theoretically have to pay them bonus and a half.
What you do, what you do is you add up whether it's you calculate their hourly wages and you times it by the number of hours worked. You add the production bonus to it, and then from that you divide it by the total number of hours, and then you get the effective hourly rate, and then from that you get the overtime rate. Yeah, it's like little math problems for each of the different ones, and under different scenarios there may be different ways on how to calculate it.
Depending on how big that bonus is, that could be a
mental note. No production bonuses this year.
So what if my business gets sued? If the employee wins, I can just close the business. I have no personal liability or risk because the business is a corporation. I mean, that's false.
That's a hard pill to swallow.
The individual liability? Yeah.
That's just, that's the first I've ever heard of something like that statutorily allows a pierce of the veil.
Of all the claims that I defended for overtime cases and represented employers, there have been many. I can't think of one where they just sued the company. It's always been the company and the president, or the company and the chief operating officer, or whatever.
Is it that way for most litigation? I mean, I've been involved in a couple of suits in 20 years or so, and everyone gets named in this, and these were corporate matters.
But getting named and then staying in the case are two different things. So if a company in, say, a traditional common law claim, you would have to pierce the depending on what the claim is, you'd have to pierce the corporate veil to get to the individual. Here, that doesn't even apply because the statute identifies this person as an employer. These are statements from the employee's perspective. So when I'm talking about typical claims, I worked off the clock.
This is good right here.
My employer didn't pay me for travel time from the workplace to the job site, and this was about 1.5 hours every day, which if the travel time from the employee's home to work is not compensable, considered work hours, but if they go to the work, they sign in, and then they have to go to another job site, that is travel time that's considered hours worked. Although my employer claims that I'm exempt, my employer keeps making deductions from my salary for any week that I don't work at least 40 hours. They just lost the exemption status. I worked through my lunch break and my employer automatically deducted 1 hour for lunch each day. That's a claim you get a lot.
That's a common one, yeah.
That is common. And it's hard to prove too, or it's hard to disprove. So the additional considerations I have, sorry I didn't realize that was kind of so small. Basically the nature of the claims, how they're fact intensive and fact issues, the fact that the employee can bring it on behalf of similarly situated employees, the damages that are allowed here, basically all goes up to, it can be very costly to the employer. So what should employers do or not do? Don't guess on the overtime laws, exemption status, pay practices, hours worked, etc. Make sure that you do your best to get it right, get advice when you need it. Do seek professional advice on your employee classifications or issues with calculations of hours worked, overtime, etc. Don't be fast and loose with your time and pay records, meaning there's one employer, I know they thought they were being fair to their employee because the person worked overtime and they were paying the person cash at straight hourly rate for the overtime. So they were getting paid, but they had nothing.
Document it.
Well, it created other issues because they were being basically paid under the table for their overtime stuff. So to prove that they were paying this person, they also have to say, oh, by the way, I just kind of violated the IRS and some tax issues there. Who do I want to come after me most? So in that type of situation, the employer had to make it right with the employee because they only paid it straight time in the cash, and then there was questions of fact as to what the amount was. Then they had to go to their accountant to figure out, okay, what do I need to do to make this right with the IRS? And they thought their rationale was, one, they honestly just didn't know. They thought that, look, it's good for the employee because it's cash wages, it's cash pay, it's good for me, so it's fair to everyone, it must be okay. No, that was not good. And sitting here, we all know that that's not good. Do have your employees review and verify their hours worked on a weekly basis. Don't ignore issues and hope that it goes away. If one employee comes to you and says, hey, I think you didn't pay me my overtime, that's a red flag for you. If you can address the problem, especially before that employee goes to an attorney that thinks that their attorney's fees are automatically going to get paid, that's a good opportunity for you to look at. That's a red flag. Look at it, address it, and try to find a right way to resolve it. See if it affects other employees as well.
That's why they have those big billboards on the thoroughfare on the way home.
Yeah, exactly.
And it's like, got 'em.
That's it, because half the time the fight is more over the attorney's fees.
Right.
And then the more you fight for attorney's fees, the more work the other attorney just did, so the more they just justified their attorney's fees. The court system has put procedures in place to kind of minimize that type of behavior, but it still happens.
Do you go on both sides of this, or always on the employer side?
Mostly on the employer side. There have been some, I would say 90% on the employer side. In fact, I just was presented with the case where I might represent the employee, and it is types of cases where I was going into the meeting thinking, you know what, I think I'm going to give them the lay of the land, but I'll probably refer this to someone else. But then when I talked to the person, looked at the facts, it looks like it's a misclassification issue. It seems it's a strong case. I'm like, okay, I'll take it, because I think it was, looks like it was a strong case, and deliberate actions were made to avoid paying the overtime. So, from what I spoke with the potential client, obviously, so we'll see. And basically, know when to fight and know when to resolve the overtime claim. So, basically, really to bring it together. So, in this fact pattern, some things so I get this fact pattern as the attorney. What is it that I do? One, I look at the exemption status, look at the duties, look at the responsibilities. Is this employee really exempt? How strong is my case on that exemption status? Look to see if there's any writing into the whether or not that 1,400 was for fixed time or fluctuating time. If they didn't have time and pay records, now if the person was not exempt, or it's in that gray area of whether or not it's exempt or non-exempt, and there's no time and pay records, then we're going to start talking about settlement early on in the case. And in some situations, say it was very clear that the person was not exempt and that the employer really does owe unpaid overtime. In that type of situation, you're never going to be able to negotiate the amount. Once the hours worked is established, the person's entitled to their overtime, and they're entitled to the equal amount in liquidated damages. So if you can determine what that number is early on, offer it to the employee. One, they take it, then that resolves the situation. You minimize the amount of attorney's fees that the other side face because it's resolved early on. If they reject it, but later on they take you all the way through trial and they win less than that, and it basically shows you can go to the court and say, I know you have to award attorney's fees here, but it's reasonable attorney's fees. 11 months ago, I offered to pay this person more than what they received at trial. My offer, anything beyond that point, was unreasonable. And sometimes courts will use that to determine whether or not what the reasonable amount of attorney's fees for the plaintiff. And so those are some of the strategies that you have in place to try to minimize what the employer's liability is going to be once the situation happens. Obviously, you'd like to have the employer, if you have an existing employer client before this happens, you want to look at their employer policies, their handbooks, and see the exemption status or if they have any issues. And with that, I think we are officially done. If you guys have any questions, you asked questions throughout, but if you have any questions now, let me know.
Perfect.
Yeah.
That was a great talk.
So,
excellent.
you're so nice.
Well
Thank
done.
you. Well, thank you. I'm glad that.
Find a slide.
We're off.
I do have one question.
Okay.
How many of these claims you see are insured, so they have coverage in place?
Not that many.
It really isn't.
No, not that many. I know there was, and sometimes, which is a shame, because even on the larger clients, with some of my larger clients where it was like a Fortune 500 company,
Right.
then they may have had something in place. I know in some policies, you have to look at the policies themselves. Some policies for a while were not wanting to extend coverage for overtime liability, but I think there are some policies now that do extend coverage for it.
Yeah, what they'll do is they'll put supplements in there of $250,000.
Yeah.
You're buying the defense, and then hopefully you can settle within those,
Yeah.
the claim limits.
But it is, there are so many overtime lawsuits out there, and there are plaintiffs, lawyers, which this is what I would not do. The plaintiffs, lawyers, where they just file the lawsuit, and the first thing that they do without looking at anything, they really will send you a demand letter with some outrageous demand, and they do it by the numbers. It's the form work. It's the same, and that's how they make their money. And
The attorneys?
I think I don't like
Attorneys get like 35% of the deal, right?
they can, but really because in this type of situation, usually it's negotiated because the employer has to be responsible for it. So part of the negotiation or the fact finding will be like, what are the hours worked, what's the overtime, and what are your attorney's fees? So usually the employer ends up, you'll have a specific amount that the employer will pay. Now, whether or not that attorney charges more to their client, that's between them and that attorney. They shouldn't, but they may if they have their agreement. I just think there's something, and sometimes people go back and forth. Is it better if I have an issue with this, do I go directly to Department of Labor, ask them for help because I want to do the right thing? If I go to them, they'll tell me what the right thing is. Well, then you might have to be paid they might find that you're doing it incorrectly, and they'll tell you what you have to pay for overtime, which is money that you're going to have to pay. But I have to double check this, but I don't think you have to pay liquidated damages if you do it, up front. And you certainly aren't going to have to pay the attorney's fees. So some employers take the option of, look, I want to go to the Department of Labor and kind of self-report and ask them for guidance on how I comply with it. Yeah, it's always like a little tricky.
So when you do your insurance coverage, does that include this kind of stuff?
What we write is there's an employer practices liability policy, and then we always include wage and hour disputes in it at a sublimit, whether it be $500,000 or $250,000. Larger clients, we include higher limits, $1 million or so. We'll negotiate with the carrier.
I wonder if, does D&O cover like personal attachment of all the IRS claims and all
Right.
that stuff?
That's the other thing. So a lot of times what we'll do is we'll include D&O, EPLI, and wage and hour on one policy. So we'll have separate deductibles. Sometimes we'll include first dollar defense. Sometimes it'll be a $5,000 deductible. That will be just like a self-retention on that because they're going to pay the first $5,000 before attorneys get involved. Well, if they want to retain their own counsel, they call her, call Kerry up, and then they pay the first $5,000 a year.
Yeah. And then here is, I couldn't find it as I was talking, but that just the listing of the press releases from the Department of Labor that just tells you, it's just pages of different things that they have done. So in the event any of your clients don't understand the impact of the overtime, you can just you could just even look at the titles of, and this is just Department of Labor investigations.
You just download it off their site?
Yeah, you can have that.
You want a copy of it, Doug?
What is this?
This is a sample of...
Like, should any of your clients, if they don't believe you that overtime and Fair Labor Standards Act can have great impact or significance?
I can, if I need it, I'll tell you.
Okay.
You have it documented.
Yeah.
Good. Yeah, and I'm going to keep this definitely close. I really think it's important, too, for just like up-and-coming companies and, as they grow, this could become a huge issue.
Well, it covers, you only need really one employee. Out of, some of the employment laws, you need 15 employees before it takes effect, 20 or whatever, but this is, you have one employee, it's going to cover you.
Yep. And then, so you know how like some attorneys do like set up companies' articles and their employment agreements, or everything they need to do when they first start. You do all that, right?
Yeah.
So you could not only do that, but you could set the employment practices.
On the employment practice
That's a
app.
huge advantage you have over 90% of transactional business attorneys that probably have no idea.
Yes. Did you get that? Is that still on video?
It's still
No. Like now he's like perfect. I need to like learn how to like do this myself. I need to do a better job at doing that. Yeah. Because then when you corporate, then I go through a checklist of things that they need to do on the employee side, and I actually have I have it written down, different employment issues or things that they may need, and then provided, okay, you can charge me by the hour, or if it's just a simple thing, maybe you just need guidance on 10 things, we could figure out a flat rate for each one or something like that.